So the Public Protector is laying crimen injuria charges against Transport Minister Fikile Mbalula. Now this after his tweet in which he described her as a hired gun. Well, today he didn't apologise. He in fact doubled down on that view in a press release in which he said he stands by that position. So how much legal trouble could he be in? Rupert Candy of Rupert Candy Attorney joins us now. Thank you so much for your time, Rupert. So crimen injuria, what is it and how hard is it to prove?
Thank you, Sally. So crimen injuria and defamation essentially has the same definition. Crimen injuria is essentially the unlawful and intentional utterances of statements which impair the dignity and privacy of a particular individual. That is the main difference between the two is that the one, defamation, deals with publication and it's in a civil court, whereas the crimen injuria charge is driven by the state, driven by the prosecution, and it's a higher burden of proof. In other words, you need to prove the person's guilt beyond a reasonable doubt, whereas with defamation in a civil court, you would need to prove it on a preponderance or a balance of probabilities.
The fact that he's now reiterated his position, Fikile Mbalula saying it first on Twitter and now actually issuing a press release saying, I absolutely stand by what I said about Busisiwe in Mkhwebane, does that make the charge potentially worse?
I don't think so. I think that there may be scope for him to argue certain defences. It may not be necessarily true, but there may be a defence of fair comment, which is not the other defense under law, which is truth for the public benefit, but rather a comment or an opinion which is not a statement of fact. There may even be, other defenses available to Minister Mbalula, like, for example, like both of them are state actors. So you have one person who is a minister, another person who's the leader of another organ of state. They both ran for public office. They both chose this career. So they can't now turn around and say, sorry, I need to take action against this because I feel that my dignity has been infringed. There may even be another defense that you could raise, Sally, and that is the fact that it is an objective fact that the public protector currently has a reputation which is in tatters. Quite apart from the Constitutional Court decision, which was an 8-2 hammering by the Constitutional Court, but there's also a number of other cases where the courts have, even gone to the extreme of issuing personal costs orders, which is, only granted against parties or legal representatives like myself, where our conduct is so egregious that as a mark of displeasure, the court says, no, you must pay this out of your own pocket. Your client can't pay it. So there may be other things. And also just on, there's a large body of judicial precedent that extends decades on crimen injuria. The case law used was quite hectic where, for example, a black man was called the K word. But here you have a situation where you have two state actors, fighting maybe politically, but this is the careers that. So there may be an issue for.
Very interesting. I want to ask you, because this applies to anyone who's ever been, ever had a slur on social media. At what point does freedom of speech end and potential crimen injuria kick in? How far can you push the freedom of speech thing?
Essentially hate speech and incitement to cause harm. So South Africa has a terrible history when it comes to racism, sexism, treatment of other people who've had struggles around the right to equality. And that obviously is non-negotiable. You will be taken to court either through crimen injuria, like we saw Vicky Momberg a few years ago, or the equality court, like Penny Sparrow. So that's where it would stop. I must just say, Sally, just insofar as the defamation and online content is concerned, you would still, the first thing would be to take a deep breath. Don't just, say something that you would research the fact whether or not it's protected expression or not. But there is a number of defences, including recently a progressive judgment from the Cape High Court, which deals with SLAP, which is essentially an acronym for Strategic Litigation Against Public Participation.
Which is about activists, right? Yeah. That's,
Exactly.
yeah,
So
absolutely.
There's even more.
Yeah, there's a lot to talk about, and actually it's a fascinating subject, and thank you very much for touching on that, and we really appreciate your time this evening. That's Rupert Candy of Rupert Candy Attorneys. That slap law he's talking about is where we see big corporates bringing more and more and more cases against small NGOs or individual activists to just shut them up. It's a fascinating subject all in itself. Thank you very much, Rupert Candy.